Welcome to The Explainer. Today, we're diving into administrative law. It's that powerful, often invisible rulebook that keeps the government in check and makes sure its decisions are actually fair. Let's get right into it. So, let's start with a question that really gets to the heart of it for all of us. We all have to deal with the government in some way, right? But what happens when they make a decision that just feels unfair, or maybe it's just plain wrong? Is there anything you can do? Well, that's precisely what administrative law is all about. And the scale of government power is just enormous. We're not just talking about big abstract politics here. It's the local council, the tax office, the people who issue licenses. This whole administrative state is a huge part of our lives. And for the most part, it provides services we all need. But with all that power comes a risk. As the famous legal scholars Wade and Forsyth put it, mistakes and even abuse are pretty much inevitable. Public bodies are run by people, and people can misread the law. And that's exactly why the law itself has to have a way to check that power. It's a failsafe. Okay, so here's our game plan. We'll quickly touch on the power of the state, then meet the law's watchdog. After that, we'll see exactly how that power is checked, and we'll wrap up by looking at why this is all so crucial for the rule of law. So, what is this legal watchdog? Well, it's a very specific, very powerful process called judicial review. And this is the main tool that you and I have to challenge what the government does in a court of law. A really good way to get your head around this is to think of it like a football game. Parliament, they write the rule book. That's the law. The government and all its various bodies, they're the players out on the field, trying to score goals. And the courts, using judicial review, they're the referee. Now, the ref's job isn't to play the game better than the players. It's just to make sure everyone follows the rules. And that brings us to an absolutely critical point. Judicial review is not the same as an appeal. It's totally different. See, an appeal asks, was this decision the right one? It's about the outcome. But a review asks a different question. Was this decision made lawfully? The court doesn't step in and say, I would have done this differently. It just checks if the rules of the game were followed. So if the court is the referee, how does it know when to blow the whistle? What counts as a foul? Well, the court looks for very specific kinds of legal mistakes, and these are known as the grounds for judicial review. The whole system is really built on this one core idea. It's a Latin term, ultra vires. It sounds a bit fancy, but all it means is beyond the powers. In simple terms, a government body can only do what the law, what Parliament, said it could do. Anything else is going beyond its powers and is legally invalid. There's just no such thing as a blank check. Now, these challenges are usually sorted into three main buckets, famously set out by Lord Diplock. You've got illegality, irrationality, and procedural impropriety. Let's quickly break down what each of those means. First up is illegality. This happens when a public body uses its power for the wrong reason. So imagine a minister has a power to do something for an economic purpose, but instead they use it for a purely political reason. That's an improper purpose, and that's an example of illegality. It also covers things like ignoring facts you were supposed to consider. The second one is irrationality. And honestly, this is a very, very high bar to prove. A decision isn't irrational just because we think it's a bad idea. To be legally irrational, it has to be, and this is the famous quote, so unreasonable that no reasonable authority could ever have come to it. We're talking about a decision that is so completely outrageous, it just defies logic. And number three is procedural impropriety. Now, this one isn't about the final decision itself. It's about the process, how the decision was made. It all comes down to fairness. Did the decision maker follow the right steps? Did they act in a way that gives everyone a fair shake? And this idea of fairness or natural justice really stands on two ancient pillars. The first is the rule against bias. Simply put, you can't be a judge in your own case. The decision maker has to be impartial. The second is the right to a fair hearing. The people affected by a decision have to get a fair chance to tell their side of the story. It's common sense, really. Okay, so let's say someone brings a case and the court agrees. The ref has blown the whistle, a foul has been committed. What actually happens next? What can the court do about it? Well, the most powerful tool the court has is called a quashing order. It's basically a giant undo button.
The court literally quashes the unlawful decision, which means it becomes a legal nothing. It's as if it never even happened. The government body then has to go back and make the decision again, but this time they have to follow the rules.
But that's not the only tool in the box. Courts can also issue a mandatory order, which, as it sounds, forces a public body to do something the law requires it to do. Or they can issue a declaration, which is just a formal statement from the court that clarifies what the law is. It sets the record straight for the future. And this is why all of this matters so much. When you put it all together, the grounds for challenge, the remedies, you see that this whole system is a cornerstone of what we call the rule of law. It's the real, practical way we ensure that the government has to operate under the law, just like the rest of us. No one is above it. Now, this whole setup is a beautiful, delicate system of checks and balances. It's all designed to control power. But it also leaves us with one final and pretty fascinating question about that balance. If judicial review is how we make sure that government doesn't go too far, who makes sure the courts don't go too far? Who checks them? Now, that is a huge constitutional question, and definitely one for another day. But it perfectly captures the constant, delicate balancing act that is right at the very heart of administrative law.